Good day, class. Welcome to my first lecture in subject PS 301, Introduction to Law. So here, my lecture will cover the chapters which can be seen in your book or the reviewer which I gave you, and that includes the first chapter, which gives us the discussion on the concept of law, followed by the world's legal system, the applicability of law, the law profession, and how or qualifications in order for one to be admitted in the practice of law or in the bar. And last chapter, which will serve as the coverage of our preliminary period, will be the Code of Professional Responsibility. Okay, so just bear with me as I proceed to my discussion. So what are the topics that we will be discussing here? First is the applicability of law. Second, the law profession. And third will be the code of professional responsibility. Okay, I'll assign the first and preliminary chapters to you, so that's your obligation to read them because some of them are can easily be understood, by just reading the text or the PDF which I sent you. Okay, so we have defined the meaning of the law since we have started our class, no? So it is a rule of conduct formulated and made obligatory by legitimate power of the state according to the US 2013. Okay, so law is a rule of conduct because it governs the conduct of human being in the society. So law is created, maybe a product of custom or a norm within a society, and which is, of course, given legitimate authority by the branch of government called legislative department. So the legislative department has the obligation and has the duty to promulgate these laws in order to correct and to set rules in the society. And of course, by virtue of the principle of law, the salus populi is suprema lex, the welfare of the people is the supreme law. So all laws created by the legislative department should be created for the purpose of promoting the welfare and the welfare of the public living in a particular country or society. Okay, that's basically the purpose of the law. So what branch which gives tooth to a particular rule in the society? It's the legislative branch of the government. Okay, so whenever there is a violation, okay, so there might be penalty, there might be fines, there might be consequences should there be a violation of any rule of conduct in the society. And that, of course, should be defined by the legislative department during the creation of particular law. Okay. In fact, it has to undergo debates, it has to undergo third readings before it will be submitted to the executive department for the signing of and approval of the law. Now, effectivity of laws. Now, under Article 2 of the new Civil Code, laws shall take effect after 15 days following the completion of their publication either in the official gazette or in a newspaper of general circulation in the Philippines, unless it is otherwise provided. So publication is a mandatory requirement before law becomes effective. Otherwise, we cannot use or utilize this law to impose penalty, to impose punishment. Okay, should there be violations of the provisions in a particular law. Okay, so unless there is publication, okay, we cannot, as a general rule, apply and impose the mandate of the law we are talking about. Okay, so that is, of course, bolstered by the case of Tañada versus Tolera, okay, which we are going to discuss later on. So if date is specified upon the lapse of the said period following its complete publication and not before, no? In the case of Tañada versus Tolera, Supreme Court said that it's the legislative department who has discretion to shorten, okay, or to follow the 15-day publication rule, okay, the period of 15 days. So in other words, the legislative department can simply put it in the effectivity clause, okay, that the law should be effective as soon as possible, okay, or that they can impose it in 20 days, in 10 days, because they have the discretion to shorten or to extend the period of 15 days. And that is, of course, the pronouncement of the Supreme Court in the case of Tañada versus Tovera. Second scenario, if no date is specified, so what if the law is silent about the effectivity? Okay, so what do we follow? We have to follow the standard, the general rule, the 15-day period pursuant to Article 2 of the new Civil Code. Okay, which may either be in the 15th or on the 16th day, depending on the language used by the Congress in fixing the effectivity date of the statute. Okay, so if the statute says that this law will be effective following the 15th day. So what is the day following the 15th day? It's the 16th day. Okay, so that's what we meant by the phrase here. Okay, that's according to Attorney Rabuya in 2009. Another scenario is if the law provides for immediate effectivity or upon approval. So effective, this law will take effect immediately. So what we mean by that is effective immediately after its complete publication, not after signing by the president. Okay, so it doesn't mean that the president has already signed or approved the bill submitted to it, okay, in the executive department. Okay, that is not a license or a guarantee that you can already use or impose the provision of the law. Because what is the reckoning point here is that there should be publication before the law takes effect. Okay, and that is a mandatory requirement. It is something that we cannot omit. Okay, so omission of publication will invalidate or will prevent us from imposing the said law. Another scenario is if the law is voluminous, so that the reckoning shall begin from the release of the last of the series. Okay, so what do you mean by voluminous law? For example, it is per set, okay, such as for example the Bayanihan Act or appropriations, for example, no. So if the law is voluminous enough, okay, so you just wait for the release of the last series, okay, of that law, and of course it must undergo first and foremost publication before it takes effect. So what do you mean by the clause unless it is otherwise provided, quote unquote, under Article 2 of the new Civil Code? It refers to the date of effectivity and not to the requirement of publication itself. Okay? So the requirement of publication may not be omitted in any event. So even if the law, for instance, would state or would say, this law shall take effect immediately. The word immediately does not omit or does not mandate that publication will be omitted or will be exempted from the mandatory requirement of publication. Okay? What is meant if the law says that it takes effect immediately, okay? Again, mandatory requirements should be followed, okay? Even if the language says that it should immediately take effect, okay? This clause does not mean the legislator may make the law effective immediately upon approval or on any other date without its previous publication. So kahit gaano mo siya kadali na gusto i-impose sa bansa, okay, again, it must undergo first the mandatory requirement of publication. Okay? So publication cannot be omitted. Okay, but the 15-day period may be shortened or may be extended depending on the discretion of the legislative department. Right? Now, let's talk about the famous case of Tanyada versus Tavera, GR number L63915, a 1986 case. So what is established here as a principle is that publication is indispensable in every case, but the legislature may, in its discretion, provide that the usual 15-day period shall be shortened or extended. Also, in this case, uh, the Supreme Court pronounced that publication of laws, okay, is part of the due process clause under the Constitution. So without the publication or absence of publication and you immediately impose the law, you immediately apply the law, then it would be tantamount to violating the due process of the person to whom you impose that particular penal law. Okay? So it is always mandatory. Note that the reason for this rule is that the basic constitutional requirement of due process must be satisfied. Okay? So before you apply the provision of any law, even if it's already approved by the president, you should again undergo the requirement of publication, because by following the mandatory requirement of publication, you are likewise following the due process clause under the Constitution, meaning the due process is being satisfied. Without such notice and publication, there would be no basis for the application of the maxim ignorantia legis non excusat. What do we mean by this? Ignorance of the law excuses no one. So when you are violating a law and you would tell the officer or the law enforcement officer that you are not aware of this law, then of course you cannot use that as an excuse, because under the maxim of ignorance legis non excusat, you cannot use your ignorance to evade the violation or the punishment or consequence brought about by the law created by the legislative department. However, the maxim of ignorantia legis non excusat does not apply at all if the mandatory requirement due process was not followed. Okay, so it is a prerequisite before this maxim will be applicable. So what are the exceptions, as set in the case of Tanyada versus Trovera to the mandatory requirement of publication? First, municipal ordinances governed by the local government code. Okay. Another, rules and regulations which are internal in nature. For instance, DOJ circulars. If the issuance concerns only the people living in that office, living in that institution, or working in that particular institution, and it does not in any way affect the public, okay, It is not penal in nature, which imposes penalty against the public, against the people. So for as long as it is internal in nature, it is exempted from the publication requirement. Third, letters of instruction issued by administrative supervisors and internal rules and guidelines. Interpretative regulations regulating only the personnel of administrative agencies. So if you have issuance regarding the protocols or rules within your office, so since it is internal in nature, then you can omit the mandatory requirement of publication. And as to municipal ordinances, these are all governed by separate law under the local government code. Okay. So where do we publish laws? Either in the official gazette or in newspaper of general circulation in the Philippines. For municipalities or cities, they use newspaper of local circulation. Okay, as long as within the jurisdiction of the local government unit. So ignorance of the law, no, as a general rule, everyone is conclusively presumed to know the law. Hence, ignorance of the law excuses no one from compliance therewith. As I've said, for violation of traffic rules, for example, no, you cannot go and tell the officer, no, I do not know this law. No, I do not know that beating the red light is a violation which would, require me to pay 1,000 pesos. No, you cannot do that as an excuse. You cannot use that as an excuse because under the civil code, everyone or every person is conclusively presumed to know the law because precisely there's a publication, and when you say publication, it is a notice to all the people, to all the government units wherever you are situated, and hence there's a presumption that we have knowledge of the laws promulgated by our government. How about the discussion on retroactivity of laws? Okay. Under Article 4 of the new Civil Code, it states that laws shall have no retroactive effect unless the contrary is provided. So what's the basis here? No? Because our legislative act or laws made by the legislative department does not look backward. Okay? So it looks forward because it is intended to punish or to correct future actions. So a legislative act that looks backward or contemplates the past, affecting acts or facts that existed before the act come into effect. Okay, and that's what we meant by retroactivity effect of a law. And under here, okay, as a general rule, laws created by legislative department has no retroactive effect. All right. So if your action, for example, of eating sopaw, okay, is not legal at all. But if tomorrow or in next week, okay, there's a law making it a crime, to eat sopaw, and of course, you cannot retroactively apply, okay, does that said law or that said prohibition to person who have eaten siopaw or burger, for the past weeks or for the past month. Because again, we always follow the general rule that law shall have no retroactive effect. But of course, in every general rule, there will always be exceptions. Okay, first, tax laws. Just recently, the news of a famous YouTuber, okay, and vlogger, who have allegedly deleted their YouTube account for the purpose of evading the payment of taxes, which is a grave violation of Philippine law, no? Because in any way, okay, you cannot evade the payment of taxes because it is your obligation. Because taxes serves as the lifeblood of the government, without which the government cannot survive. The government cannot build infrastructure, cannot promote social services, cannot help and address the needs of the people. Okay, so in tax laws uh, there is retroactive effect. So even if, for example, those bloggers who were famous now, okay, even if they have received the income 2 years ago or 1 year ago, it will always be subject to tax payments. Why? Because the prohibition on retroactivity does not apply to tax laws. Okay, so interpretative statutes. Okay, that's one of uh, the examples or the exceptions. No, one example for this would be revenue memorandum orders by the BIR. No, these are mere interpretation of statutes. Third, laws creating new substantive rights. Okay, that's also an exception. Curative statutes. Okay, so whenever there is a law and the law or the former law is incomplete or somehow requires clarification, so you have to create a curative statute in order to correct the lacking matters in the previous law. Remedial and procedural laws, no, these are found in the rules of court. Emergency laws, okay, that's also an exception. Seven is when expressly provided, that this law shall have retroactive effect. When the law itself, okay, declares that the effectivity of law will be retroactive. Okay. 8. Penal laws favorable to the accused provided that the accused is not a habitual delinquent. So if, for example, you have committed a certain crime and later on um, there is a law which somehow lessens the penalty of the crime you have committed. So in that case, it will retroactively apply to you because it's favorable on the part of the accused. But there must be a requirement that you are not a habitual delinquent. When you say habitual delinquent, you have been doing that crime for many years, no? Or you have been previously uh, accused or convicted for the same crime, okay, or for another crime, okay. So those are the exceptions to the general rule that laws shall have no retroactive effect. Okay. So number one there is tax laws, no? So dili gyud maka evade, no, from the tax obligation, from our tax obligation. Okay. Non-retroactivity of laws vis-a-vis judicial decisions. So judicial decisions have no retroactive effect. Okay, again following the general rule. When the doctrine of the Supreme Court is overruled and a different view is adopted, the new doctrine should be applied prospectively and should not apply to parties who had relied on the old doctrine and acted on the faith thereon. Okay, so this is what we call flip-flopping decisions of the Supreme Court, because sometimes the decision of the Supreme Court is not consistent. No, it would depend on the justice, okay, or the judge who is the ponente of that particular decision. No, sometimes they're saying black, no, but later on they would say it's white, no, and there is no consistency. So how do we apply that? How do we deal with that? According here, there shall be no retroactive effect because when there is a doctrine of the SC and it was overruled by a different view or a new view, as reflected in the current and recent decision, then the new doctrine should be applied prospectively. Okay? So that's why when you answer in the exam, okay, you always cite the most recent case because that would be or that would serve as the prevailing doctrine, the prevailing principle, okay, on a certain matter. Lex prospicit, non respisit. What do we mean by this? No, this maxim means the law looks forward and not backward. Again, it's still consistent with the provision of the new civil code that there shall be no retroactivity of laws. The retroactive application of a law usually divests rights that have already become vested or impairs the obligations of contract and hence is unconstitutional. Okay? So let's say A owed money to B, no, nangutang si A kay B, and then their interest for the inka or for the utang was 5% per month. Okay, and here comes another law which prohibits, okay, the imposition of monthly interest to more than 3%. Okay, so in that case, it would affect, you know, the previous contract between A and B because their contract or their agreement was 5% per month. Okay, so therefore it impairs the obligations of contract. Okay, hence it is unconstitutional as held by Chavez versus PEA. And how do you call that? Or what would be our legal maxim for that? Lex pospicit, non respisit. Okay, the law looks forward and not backward. So let's talk about the waiver of rights still in the new civil code. It is a voluntary and intentional relinquishment or abandonment of a non-existing legal right, advantage, benefit, claim, or privilege, which except for such waiver the party would have enjoyed. The voluntary abandonment or surrender by a capable person of a right known by him to exist with the intent that such right shall be surrendered and such person forever deprived of its benefit, or such conduct as warrants an inference of the relinquishment of such right, or the intentional doing of an act inconsistent with claiming it. That's the case of Cruz versus Co. Incorporated versus HR Construction. Okay, so what is a clear and simple example of waiver of right? Okay, for example, A owed money to B for the amount of 100,000. Okay, so after 20 years, there was no demand coming from B about the debt of A. Okay, so nilapas na og 20 years to 30 years. Okay, no demand expressed by B as the creditor in that particular loan agreement. So in that case, that's automatically a waiver of his right to be paid by the debtor. Okay. Another example for that is, let's say you have a property located in, let's say, in Kalinan. Okay. So you have a 500 square meters property lot. Okay. And you notice that after 5 months of purchasing that property, there have been three, maybe four family who have built their houses within the property owned or within the property you just bought. Okay, so even if you notice and even if you observe that they are using your property, you did not do anything about it. Okay, you did not complain, you did not tell them, you did not, of course, ask them to vacate the property. Okay, so that's an example of an implied waiver of right. Okay, so after 30 years, 20 years, hindi mo pa rin talaga Hindi ka pa nag-demand na i-dictate nila yung premises o yung property mo. Okay? So that's considered to be a waiver of your right as an owner of the property. So what are the kinds of rights? Okay? We have natural rights, political rights, and civil rights. When you say natural rights, those which grow out of the nature of man and depend upon personality. These are inalienable rights. Right to life, liberty, privacy, and good reputation. Even if you go to another country, these rights will never be deprived from you because these are natural rights. Second, political rights consist in the power to participate directly or indirectly in the establishment or administration of government. Can you transfer your political right to another person? The answer is no, because political rights are personal in nature. Okay? Those are right of suffrage, right to hold public office, right of petition. The right to suffrage you cannot be transferred to your son or to your daughter because it's a personal affirmation of your right. It's a personal exercise of your political right under Article 5 of the Constitution. Okay, your right to suffrage. Right to hold public office. Si mayor, for example, okay, mayor doesn't feel, no? Hindi na niya feel na maging mayor sa isang city. And he wanted to transfer it to his daughter. Can he validly do that? The answer is no, because it's a personal right. No? Political rights are personal rights. Third, civil rights, those that pertain to a person by virtue of his citizenship in a state or community. Property rights, marriage, equal protection of laws, freedom of contract, and trial by jury. So usually civil rights differ from one place to another. That's why we have doctrines under private international law or the conflict of laws in order to reconcile the possible conflicts of laws from one country to another. Okay? So usual examples for this when a foreigner marries a Filipina woman, okay, and their relationship become sour, so they have decided to legally separate. So there's a conflict now, no? What do we follow? Do we adhere to the law of the Philippines or do we adhere to the follow of the nationality of the foreigner? Okay, so that is an example of a conflict of law. Judicial decisions, what are these? Judicial decisions applying or interpreting the laws of the Constitution shall form a part of the legal system of the Philippines. Okay, so all the decisions, the jurisprudence of courts can be part of the legal system of the Philippines. Okay, so what are judicial decisions? This is limited to decisions of the Supreme Court. RTC decisions, CA decisions has no binding effect and it is not part of the legal system of the Philippines. Even the decision of CTAs, Court of Tax Appeals or Municipal Trial Courts, no? Again, what is being contemplated here is a Supreme Court decision. Rendering of judgment by reason of silence of law. Okay? So no judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. So let's say you're a judge and you cannot find any law available in the Philippines which would be applicable in the given case, no, in the case at bar. So in that case, it should not be a reason for you to decline or refuse to render judgment because the primary purpose of a court really is to provide justice, okay, to promote justice, okay, to settle disputes between people. Okay? So in that case, you can apply the general rule of law, the law on equity, okay, in case of silence and obscurity or the law in the given case. Okay. However, in criminal prosecutions, the judge must dismiss the case if a person is accused of a non-existent crime following the maxim nullum crimen nulla pena sine lege. So what do you mean by this? Okay. There is no crime when there is no law punishing the act. No? Yan yung example ko. For example, ngayon, September 2, okay, kumain ka ng burger. Tapos, after 7 days, merong batas na ginawa. Pinagbabawal ang pagkain ng burger. Okay? So, what's the penalty? The penalty is reclusion perpetua, no? 20 days, 20 years and 1 day to 40 years. That's the penalty. Can you apply that? Of course, you can use the legal maxim nullum crimen nulla pena sine lege. So when there is no crime, when there is no law punishing the act. So you cannot be punished for the things that you have done 7 days ago. Because at that time when you exercise that act, and when you do such acts, okay, there has been no law punishing what you have done at that time. Okay? So presumption in case of doubt in the interpretation of laws. Okay? How do we interpret? In case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Okay, so of course, no, that's that is easily understood. It can be easily understood, no. So you'd always uphold, okay, the general law and the rule of justice and fairness. Okay. So in the materials that I gave you, okay, I believe there is a discussion there of the statutory construction. So what is the statutory construction? It is the art or process of discovering and expounding the meaning and intention of the authors of the law with respect to its application to a given case where that intention is rendered doubtful, among others, by reason of the fact that the given case is not explicitly provided for in the law. Okay? So what do you mean by this? Okay? Statutory construction it's actually a process that you look into the meaning of the law. Okay? You look into the intent and purposes of the authors who crafted the said law. Okay? Ano ba talaga yung purpose nila? Okay? You look at the whereas clauses. What's the intention? Why did they create this balaod? Why did they create this law in the first place? Because of this problem. During the time when they created the law, the situation was this and like that. Okay. So it is important in our study of statutory construction. It is important to distinguish construction and interpretation. When we say construction, it is the drawing of conclusions with respect to the subjects that are beyond the direct expression of the text. While interpretation is the process of discovering the true meaning of the language used. Okay? So, when we say construction, it looks beyond the direct expression of the text. Okay? So, you look at the context of the situation at the time when the law was crafted. Ano palang sitwasyon noon? Bakit nila ginawa ito na batas? Ano pala ang pinaka-intention nila? So you go beyond the expression of the text. You go beyond the language of the text or the language of the law. While interpretation is discovering the true meaning of the language used. Okay? Interpretation is limited to exploring the written text meaning it's within the text. Okay, so you have to look at the text or the language of the law itself, of the provision. Okay, you don't go beyond, you don't go extrinsically, you don't go outside the text. While construction, on the other hand, is the drawing of conclusions respecting the subjects that lie beyond the direct expressions of the text. Okay, so what is an example of this? Let's say, under the Constitution, every person is presumed innocent until proven guilty. Okay, so how do you construct that? If you, if you go beyond, you know, if you look beyond the expression or the direct expression of the text, you look at the situation before this law was created. Okay, during the Spanish time, no? During the Spanish time, there was no separation of church and state. There was no um, due process, and basically that was the rule there was reversed. No, so instead of presumption of innocence, there is presumption of guilt at that time. No, in the 1500s when we were under the colony of the Spanish government. Okay, so that's construction. When we say interpretation, it's naturally in understanding the law or the provision based on how it is written. Okay? If it is direct and if it is not obscure and it is not susceptible to any other meaning, then you just basically apply that. Okay? So what's the general rule in the study of statutory construction? You have to remember that the primary purpose of the courts and the justices who make decisions is basically to apply the law. Okay? Interpretation and construction is not the main purpose of the court. It's the application. When the law is clear, apply it. And that's it. Okay? So where do you use or when do you use construction and interpretation? If there is obscurity, you know, if there is vagueness, okay? If the provision or the language or the text is susceptible to two or more meanings or susceptible to two or more different interpretations. Okay, but one thing you need to remember is if the law is clear and not ambiguous, then apply the law. No? And what's your basis? The dura lex sed lex. The law may be harsh, but it is the law. Okay, so you do not apply immediately interpretation. You only interpret if there is vagueness, no, in the language or text of certain law. Okay, so that's the end of the first part of my lecture.